Hey everybody, welcome to another episode of Foreclosure Help 777, where we talk about everything foreclosure related. And this is my private Facebook group, which you can join if you are on Facebook and you're going through foreclosure. And this is where we help each other out. And if you have not subscribed to my channel, I hope that you will subscribe to it and follow it for more interesting updates that help you fight your battle. And today we're going to start with the verse of the day. Okay, so the verse of the day is 1 Peter 5:8, and it says, "Be alert and of sober mind. Your enemy, the devil, prowls around like a roaring lion looking for someone to devour." And in foreclosure defense, of course, the enemy is the devil, and he's looking to take your house. So it's up to us to stand together and fight the devil any way, shape, or form that we can. Today we're going to talk about something a lot of people like to talk about, and hopefully this will shed some light if you're not already familiar with the MERS system. The MERS system is a database, so let's get started. The presentation for today is called Foreclosure and Mers. What is MERS? MERS is tied to the mortgage or deed of trust, the document recorded in the county records. The actual loan, the note, is owned by someone else. MERS may track who that is, but it doesn't own or transfer the note itself. Now, Intercontinental Exchange, or ICE, acquired MERS Corp Holdings in 2018, making it wholly owned subsidiary MERS Corp operates the MERS system, a national electronic registry tracking mortgage servicing rights and ownership, which is now part of ICE's mortgage technology business. And the key details of this acquisition: ownership: ICE acquired a majority stake in 2016 and bought the remaining equity in October of 2018. So the role of MERS, or MERS Corp Holdings, it operates the MERS system and MERS registry, or e-registry. Its subsidiary, Mortgage Electronic Registration System, serves as mortgagee in the land records. The purpose is the acquisition allows ICE to leverage its technology to streamline the mortgage industry's shift from paper-based to digital processes. And the operation, the MERS system, moved to an ICE data center, strengthening its role as a registry for over 5,000 members. As of today, MERS Corp Holdings is a part of the ICE mortgage technology portfolio. MERS equals Mortgage Electronic Registration Systems, which is a database system. It tracks mortgage servicing rights and ownership transfers. It's used by banks to avoid recording assignments in the county records every time. MERS is like a digital tracking system for mortgages, but the county records only show MERS, not every transfer behind the scenes. What MERS is not: MERS is not the lender, the investor, the note holder, or the servicer. It's usually listed as nominee for the lender and its successor and assigns. MERS doesn't own your loan. It's acting as a placeholder in public records. Before MERS, every transfer required a recorded assignment. It's costly and slow. After MERS, transfers happen internally. Only MERS stays on record. Why banks liked it? Well, it saved them money, speeds up securitization, and avoids recording fees. What a MERS system looks like behind the scenes: loans identified by a MIN number, or a mortgage identification number. Fields like the servicer's name, investor, sometimes status updates, and milestones. This is where banks update who is servicing the loan, not the public, but the public never sees this. What is a MERS milestone? A milestone is an event recorded in the MERS system. Examples: when a loan is boarded, a servicing transfer, a default, a foreclosure referral, or if it's paid off. Important point: these are all internal entities, not always reflected in the public records, something you want to request in discovery if your mortgage is MERS. Now, I did in my own foreclosure. I did request a copy of all the MERS milestone reports, and they actually sent them to me in discovery, and yes, it did help my case when I was fighting the bank. MERS milestones are like a private timeline of your loan. How assignments work with MERS? Well, you have the original mortgage, MERS as nominee for lender. Later assignment, MERS assigns the mortgage to XYZ Bank. Now the key issue is MERS signs as nominee, not as actual owner. And there's a difference here between void versus voidable assignments. The general legal concept is void means it has no legal effect at all. Voidable means it's valid unless challenged. And what courts often say is borrowers usually cannot challenge assignments between third parties, but the plaintiff must still prove standing and the right to enforce. Courts often treat assignment issues as voidable, not automatically void, but they still require the foreclosing party to prove it has the right to enforce the loan. Where MERS becomes a problem in cases, potential issues, missing or unclear chain of title transfers, MERS signing years later, robo-signing concerns, separation of the note and mortgage arguments, confusion over who owns the loan and who can enforce it. MERS can simplify things for banks, but it can complicate things in court. Questions you got to ask: who actually owns the loan? Who authorized the assignment? And does the timeline even make sense? How to look up a loan in MERS, which is a public tool, what to look for on your mortgage document, why MERS arguments sometimes fail in court, and how MERS interacts with securitized trusts. We're going to look up I'm going to show you in a minute how to do the look up in the MERS website, so you can see if your loan is there in just a minute. MERS isn't illegal, but understanding what it is and how it's used can help you ask the right questions when a foreclosure case doesn't make sense. Here's some cases that you guys need to know about. And of course, you can look these all up online. Cervantes versus Countrywide Home Loans is one of them. What the court had said is MERS system is not inherently illegal. Naming MERS as the nominee is generally valid. Courts have said MERS itself isn't illegal, but that doesn't mean that every use of MERS is valid. Mortgage Electronic Registrations, Inc. versus Rivordo. What the court said: MERS can act as nominee, but must show authority from the actual note holder. MERS can act, but only if it actually has authority from the real party in interest. Okay. Then there's the U.S. Bank National Association versus Ibanez. What the court said: foreclosing party must prove it held the mortgage at the time of foreclosure and it had a broken chain. Courts require proof, not assumptions, when it comes to who owns the loan. Then there's the Belastri versus Aquin Loan Servicing. What the court said: separation of note and mortgage creates issues. MERS had no beneficial interest. Important. Not binding in most places. Courts are split. Some courts have questioned whether MERS can assign interest it never owned, but this argument doesn't win everywhere. Then there's De Brunner versus Deutsche Bank, National Trust Company. What the court said: foreclosure doesn't always require producing the original note. Explain it simply: courts don't always require the original, but they still require proof of authority. Courts across the country have generally upheld that the MERS system, but they also require the party trying to enforce the loan to prove it has the legal right to do so. The real issue isn't just MERS, it's whether the paperwork and authority behind the scenes actually line up. Then there's Montgomery County, Pennsylvania versus Mortgage Electronic Registration Systems, Inc. And what this case was about: well, the recorder of deeds in Montgomery County, PA, sued MERS, and the argument was MERS was bypassing county recording requirements, costing counties millions of recording fees. They said MERS was avoiding the public recording system and depriving counties of revenue. And what the court had decided The Third Circuit ruled in favor of Mers. The key holding: Pennsylvania law did not require every mortgage transfer to be recorded. I wish it wasn't that way though, guys, I'll tell you that. Mers system is allowed under that law. Counties rely on recording fees and public records, and Mers created a private system that bypassed that, which led to lawsuits like this. Here's another key case that everybody should read. It's Bain versus Metropolitan Mortgage Group, Inc., or Bain versus Mers is what it's called as well. What the case was about: the homeowner challenged whether Mers could act as beneficiary in a deed of trust when Mers did not hold a promissory note and Mers was listed only as nominee. What the court held: the Washington Supreme Court said Mers is not a lawful beneficiary and it does not hold the note. Some courts have pushed back on Mers. In the Bain case, the Washington Supreme Court said that Mers cannot be treated as the beneficiary of a loan unless it actually holds the note. In other words, just calling yourself the beneficiary doesn't make it true. And why this case matters: this is one of the most cited cases against over-reliance on Mers language. It reinforces the note matters, the real party and interest matters. You can't just rely on wording in the mortgage. A defective Mers assignment occurs when the mortgage electronic registration system, Mers, transfers a mortgage without proper legal authority or ownership of the underlying promissory note, often rendering the foreclosure invalid. Courts have found that Mers, acting as nominee, cannot validly assign the note, leading to broken chains of title and voidable assignments. Here's some key aspects in defective Mers assignments. Invalid assignments. Assignments from Mers are often invalid if they do not follow state law, or if Mers did not hold the note, as a mortgage assignment alone without the note is legally meaningless. The split instrument. A major issue arises when Mers attempts to assign the mortgage while the note has already been securitized or sold, causing a separation or bifurcation that may render the debt unenforceable. Split judicial authority. Some courts have held that Mers lacks authority to assign notes. Others have ruled that Mers, as nominee for the lender, can still execute valid assignments, or that the note holder, not Mers, is the rightful party. And then there's robo-signing and fraud. Investigations have indicated that a high percentage of Mers assignments may be fraudulent or handled by robo-signers who sign documents without reviewing them, making them legally invalid. Mers and hidden risk in property titles. Did you know that in many mortgage transactions, the public record may not tell the full story? A law review article from the Brooklyn Law Review highlights a critical issue. When a mortgage is tracked through Mers, the public record may show only Mers, while the true owner of the loan, the note, may be somewhere else entirely. And why does this matter? A mortgage can be released, but the underlying debt, the note, may still exist. If the wrong party is paid, the real note holder could still have a claim, and in some cases, this can create clouded title or hidden ownership issues for the buyers. Okay, and the source for this was the Brooklyn Law Review, Home Buyer Beware, Mers and the Law of Subsequent Purchasers. The bottom line: Mers isn't illegal, but it can make ownership and title issues more complex than they appear. And I came across the official Mers System Procedures Manual, and what it says is really important. Mers admits it is not a legal system of record and does not actually transfer ownership of loans. It only tracks information reported by its members. In other words, Mers is a private tracking system, not proof of who owns the note or the loan. That means that the public record might show Mers while the real ownership could be somewhere else behind the scenes. If you want to read this for yourself, I've posted a copy on my Facebook page, which I was going to show you right now. Okay, now I posted this on my Facebook page under files if you want to get a copy of it, or you can probably Google it and find it just as easily, but it's the Mers System Procedures Manual. It's a PDF file. This one was effective date November 16, 2025, so it's sort of recent. It has contents, as you can see here. It talks about everything you ever wanted to know and didn't want to know about Mers. Talks about the membership, what happens when it changes, the system itself, how to log in, loan registration requirements, system actions, this kind of stuff. Guys, if you have a MERS mortgage, you'll want to read this just to be educated on all this stuff, because it is important. You'll be able to understand when you get your discovery from your loan servicer. You'll be able to understand it way better if you read all this. So I'm just going to kind of go through it real quick so you can see some of the topics that they talk about in this book. And again, it is kind of lengthy, but it is what it is. And you can see everything that you didn't want to know in here as well. And so here it is. Okay, so that's on my website, so you guys can read this. And then the other thing that I also posted on my website was this, which is that Brooklyn Law Review article, Homebuyers Beware, MERS and the Law of Subsequent Purchasers. And this is interesting as well, as we talked about briefly about how if it shows up in MERS, it might not actually be there. And so, again, this is another thing you should read just to be educated on MERS and how there could be a problem. Okay, guys, that concludes our presentation for this week. I hope that it was informative for a lot of people. If you have questions or comments, please leave them below and I will try to respond. If you have a problem with your own mortgage or you want me to look at something, you can always send me an email. My email address is foreclosurehelp777@gmail.com. And as always, everyone have a blessed day.